to Sarah and James's stories, but what I just want to do is explain why I think that it is possible to include this in the bill. As far as I know, the Taoiseach has said that he's got opinion from the Attorney General that it's not possible to include this, that a constitutional referendum would be required. This bill was drafted by myself, Dr. Ruth Fletcher from Keele University, and Dr. Emer Spain from the University of Limerick, who cumulatively have over 35 years' experience specifically working on abortion law in Ireland and specifically examining end-of-life decisions within an Irish context. So we have thought about this issue, and we've been thinking about the extent of the protection afforded under Article 43.3 for quite some time. I think what the advice from the Attorney General might be is that in order for a termination to be legally permissible under Article 43.3, there needs to be a threat to the life of the woman before termination is possible. That is based on the decision in the X case, and as we know, the decision in the X case involved a situation where there was a medical threat to the life of the young girl in question. But what myself, Dr. Fletcher and Dr. Spain would argue is that the interpretation of Article 43.3 isn't just limited to that very narrow set of circumstances. The decision in the X case was based on the facts of that case. The Supreme Court couldn't examine Article 43.3 in any other context. It couldn't speculate as to what might occur in situations in relation to fatal fetal abnormalities. It couldn't comment on the state of the law. It couldn't develop the law in any other way. It was restricted to deciding that case on its facts. If a case involving a woman who had a diagnosis like Sarah and James had, if that came before the Supreme Court, I think it would be open to the Supreme Court to say, yes, this is also constitutional, that Article 43.3 allows terminations in these circumstances too. The problem is, of course, that when a woman gets a diagnosis like this, the last thing that she's going to do is go to her solicitor and end up in the High Court to try and develop the law. What she's going to do is book a flight, and she's going to go through that awful circumstance, sometimes leaving her children at home, sometimes leaving all her family at home. What I would say is that when the Constitution was amended in 1983 to introduce, or to protect the right to life of the unborn, I don't think it's likely that people intended the Constitution to protect life which has no capacity for life outside the womb. I don't think when we passed that constitutional amendment, it was in the minds of the people that what we were protecting here was unviable life. What the Constitution does is it protects the right to life of the unborn with due regard to the equal right to life of the mother, and the state is under an obligation to protect that life insofar as is practicable. So I think it's open for Article 4, for terminations to be allowed in these circumstances for three reasons. And the first is that I don't think, and Dr. Fletcher and Dr. Spain agree, that unborn in this context means the capacity to be born. So that life which does not have the capacity for life outside the womb is not protected. Secondly, if I'm wrong on that, and we admit that we may be wrong on that, that what we're doing here is we're equating unborn life with the life of the woman. And the Constitution equates unborn life with the life of the pregnant woman. And I think that where the fetus has no capacity for life outside the womb, where it cannot sustain independent existence, the Constitution cannot possibly try to equate those two lives. It's not possible to equate life which has no prospect of independent life and that of a woman. And if we're wrong on that, the Constitution only requires the state to protect and vindicate that right to life insofar as is practicable. And when we talk about practicable, what we would argue is that it's not practicable to force a woman to carry pregnancy to term for 40 weeks, knowing every day that she will not have a baby after that. It's not practicable for a woman to have all the health complications that are associated with pregnancy. Pregnancies aren't wonderful, joyous walks in the park. Pregnancies are very hard on a woman's body. Giving birth is very hard on a woman's body. And it's not practicable to force her to go through that when there's no baby at the end of it. It's also not practicable to force a woman's family to go through this 40 weeks knowing that there won't be a baby at the end of it. It's not practicable to say to children, yes, Mummy has a baby in her tummy, but that baby, we won't have a little brother or sister when that baby comes out. It's not practicable for the government to force women to face up to those. And what the Constitution in Article 41 does is it protects the rights of the family, and it protects the institution of the family. And I think that when we're talking about what's practicable in Article 43.3, it's not, we have to think about the rights of the family in Article 41 as well, and we have to think about the rights of the parents, we have to think about the rights of the children, if the woman already has children as part of that family. We have to think about the fact that those two people in a marriage, in an Article 41 context, have a right to have more children. And you know what? Sometimes these pregnancies can impact the ability of a woman to have further children. It can impact on their right to found a family, which Article 41 protects. I don't think a test case is going to come up here. I think a woman would have to be incredibly strong to walk into the High Court and ask the High Court if it's possible to terminate her pregnancy in those situations. So I think it's incumbent on the government to at least discuss in the chamber whether this is possible. I think that it's important that this is given full legislative attention. It is certainly arguable that it's constitutional to introduce this amendment. There are no definites. You know, the government introduces or passes acts which have been in the past declared unconstitutional, which they were fully convinced were constitutional. So there's no definites when it comes to the constitutionality of legislation. But what we say is that it is certainly arguable, that it is fully within the Constitution to legislate for this, and we would call on the government to do so. I think the word barbaric was used by Deputy Halligan in the chamber today, and it is barbaric to force women to do this.
Thanks.